Once the officers got wind of Novak's page, they all stopped what they were doing to take a look at it, and a couple of them tried to figure out who did it. One officer said they just wanted it down. They took several steps to make that happen. A Facebook battle ensued. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So, if you were ever wondering what the standard is for parody, let's spend a few minutes together and find out what this Judge Thapar, I'll get it right, says. American Pie, baseball, and the right to ridicule a government each holds an important place in American history and tradition. So thought Anthony Novak when he created a Facebook page to mock the Parma Police Department. He styled his page to look like the department's official Facebook page, but the similarities ended there. Novak shared posts like an advertisement for a pedophile reform event at which pedophiles would receive honorary police commissions. Novak's page delighted, disgusted, and confused. Not everyone understood it, but when it comes to parody, the law requires a reasonable reader standard, not a most gullible person on Facebook standard. The First Amendment does not depend on whether everyone is in on the joke. Neither is it bothered by public disapproval, whether tepid or red hot. Novak's Facebook page was either a protected parody in the great American tradition of ridiculing the government or a disruptive violation of state law. Maybe both. At this stage, we decide only whether the officers are entitled to qualified immunity. For some of Novak's claims they are, but for others they are not. So that's the scope of this discussion, is qualified immunity. We're not talking about dismissing the claims we're talking about dismissing the claims as to qualified immunity, but we're not talking about anything else. This is just on the officer's qualified immunity, which the qualified immunity standard is that as long as an officer is obeying his clearly established law and policy, he or she is immune from personal lawsuit or personal liability. So you can't sue the officer individually as a person and get to their house and their car and their assets and their money. You could only sue the police department if there has been a otherwise provable violation. This case comes to us after a motion to dismiss, so we take the facts as Novak alleges them and draw reasonable inferences in his favor. Novak created a farcical Facebook account designed to look like the police department's official page. The page was up for 12 hours and published several posts. Among the posts was a recruitment advertisement that strongly encouraged minorities to not apply. Novak also posted an apology from the department for neglecting to inform the public about an armed white male who robbed a Subway sandwich shop, while promising to bring justice to an African-American woman who was loitering outside the Subway during the robbery. The page was polarizing. Some of its about 100 followers thought it was the funniest thing ever. Others were angry, and yet others were confused, wondering whether this was the actual Parma Police official Facebook page. A handful of people were so angry or confused, they called the police station. In all, the station received 12 minutes of calls. Wait, this everything we're about to read is over about 12 hours of Facebook and 12 minutes of police department calls. Others continued to enjoy the page, which soon became a platform for a wide range of citizens to air their grievances about the department. The officers later testified that they worried the page would confuse the public and that the likely result is that people would call. One of the page's audiences, the Parma Police Department, did not find the page funny. Once the officers got wind of Novak's page, they all stopped what they were doing to take a look at it, and a couple of them tried to figure out who did it. One officer said they just wanted it down. They took several steps to make that happen. A Facebook battle ensued. First, the department posted a warning on its official Facebook page. The warning alerted the public to the fake page and assured them that the matter was currently being investigated. Then Novak reposted the exact same warning on his own page. He claims he did this to deepen his satire. For the same reason, Novak deleted pedantic comments on his page explaining that the page was fake, as these clumsy explications only belabored the joke. After that, the conflict moved offline and into the real world. Officer Kevin Riley assigned Officer Thomas Connor to the case and tasked him with the finding out of who ran the page. So Connor sent a letter to Facebook requesting the page be shut down immediately. He also sent an email to a different Facebook representative asking that the page be taken down. The police also informed local news outlets of the investigation. The case of the fake police page even appeared on the nightly news. At that point, Novak decided to delete his creation. He had heard of the department's investigation and was worried about the consequences. Though Novak was done posting, the police department was not done investigating. They still wanted to find the person behind the laptop, so Connor subpoenaed records from Facebook. Riley directed Connor to go further and obtain a search warrant for Facebook. Novak alleged that Connor made several material misrepresentations and omissions to obtain that warrant. The warrant was still issued, and Facebook disclosed that Novak was the one behind the fake account. Once the department realized that Novak was the cyber culprit, Riley directed Connor to obtain 2 more warrants, one to search Novak's apartment and one to arrest him. The warrant said that Novak unlawfully impaired the department's functions in violation of Ohio law. Novak responds that, other than 12 minutes of phone calls to the department, the police department suffered no disruption to its functions. And Novak claims the officers were unaware of the 12 minutes of call time when they obtained the warrants. But once again, the warrants still issued, and the department arrested Novak. The case went to trial, and Novak was acquitted. After he was acquitted of the criminal charge, Novak sued the city of Parma and officers Riley and Connor. He alleged in over 30 claims that the city and its officers violated his constitutional and statutory rights under federal and Ohio law. The defendants moved to dismiss his 30-plus claims. The district court granted the motion in part and denied it in part, with 26 claims left standing. On appeal, the police claimed that qualified immunity shields them from Novak's lawsuit. We review de novo, or brand new, whether the officers are entitled to qualified immunity, and issues inextricably intertwined with that question. Qualified immunity protects government officials, like the Parma police officers, from being liable for money damages if their conduct did not violate clearly established statutory or constitutional rights of which a reasonable person would have known. The doctrine balances the need to hold public officials accountable when they exercise power irresponsibly with the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. Officers Riley and Connor are entitled to qualified immunity unless they violated a federal statutory or constitutional right, and 2, the unlawfulness of this conduct was clearly established at the time. For the right to be clearly established, the constitutionality of the conduct must have been beyond debate in the particular circumstances before him. The Supreme Court has cautioned that clearly established must not be defined at a high level of generality. Instead, we must be sensitive to the fact that police officers work in the real world, which is often messier than law books would have us believe. So when it comes to holding police officers liable for heat-of-the-moment decisions they make in the line of duty, abstract legal principles will not do the trick. So the court does take into account the reality of policing the streets and how we are sitting in courtrooms behind law books, and to try not to overestimate how much discretion or how much ability or how quick officers can react in different situations. On both the facts and the law, specificity is our guiding light, but we must also be mindful of the stage of the proceedings. This case reaches us early after a motion to dismiss, and while we always hope to resolve qualified immunity claims at the earliest possible point in litigation, we cannot resolve such claims when we need more factual development to do so. We consider each of Novak's claims under these standards. Retaliation. Novak argues that the officers retaliated against him because of his protected speech. This turns on two issues: whether his Facebook page was a parody and whether the Parma police had probable cause. Whether the Parma police had probable cause to arrest Novak for his page. This is getting fun. Because resolving both issues involves questions of fact, the claim survives. To allege a retaliation claim, Novak must show he engaged in constitutionally protected activity. The officer's adverse actions caused Novak to suffer an injury that would likely chill a person of ordinary firmness from continuing that activity, and the officers were motivated, at least in part, by his exercise of his constitutional rights. At this stage, the parties dispute whether Novak's Facebook page was protected speech. Was Novak's speech protected as a parody? The Supreme Court has repeatedly reminded us that almost all speech is protected other than in a few limited areas. Those limited areas include speech expressed as part of a crime, obscene expression, incitement, and fraud. It is clearly established, though, that parody does not fall in one of these limited areas. It is protected speech. The question then is whether Novak's page was a parody. The officers claim that his Facebook page was false and meant to mislead the public, not a parody. But they are wrong to think that we just look to a few confused people to determine if the page is protected parody. Our nation's long-held First Amendment protection for parody does not rise and fall with whether a few people are confused. Instead, we must apply a reasonable reader test. Speech that could not reasonably have been interpreted as stating actual facts is a parody, even if patently offensive. That means outwardly offensive, as opposed to needing to read into it to get to the offense. The test is not whether one person or even 10 people or even 100 people were confused by Novak's page. Indeed, the genius of parody is that it comes close enough to reality to spark a moment of doubt in the reader's mind before she realizes the joke. The germ of parody lies in the definition of the Greek parodia, as the song sung alongside another. And masterful parody may skirt that line even closer. Benjamin Franklin's 1784 satirical essay in the Journal de Paris came so close to the truth that it anticipated reality before it happened. Franklin spoke of the benefits of daylight and joked that the French should consider waking up earlier to save money on candles. In his tongue-in-cheek proposal, Franklin recommended several measures for the implementation of his plan. He suggested that every morning, as soon as the sun rises, let all the bells in every church be set ringing, and if that is not sufficient, let cannon be fired in every street to wake the sluggards effectually and make them open their eyes to see their true interest. And that's from Benjamin Franklin, an economical project letter to the editor of the Journal of Paris, because it was in English. Through his satire, Franklin predicted the reality of daylight saving time, which would come a century and a half later. And a parody need not spoil its own punchline by declaring itself a parody. Parody serves its goals, whether labeled or not, and there is no reason to require parody to state the obvious or even the reasonably perceived. Imagine if The Onion were required to disclaim that parodical headlines like the following are, in reality, false. Presidential debate sidetracked by Booker. De Blasio arguing about best place in Lower Manhattan to get tapas. John Bolton urges war against the sun after uncovering evidence it has nuclear capabilities. The law of parody does not require us to strain credulity so far, and that is not because everyone always understands the joke. Instead, the test for parody is whether a reasonable reader would have seen Novak's Facebook page and concluded that the post stated actual facts. Our nation boasts a long history of protecting parody and satire, from the early cartoon portraying George Washington as an ass down to the present day. Satirical cartoons have played a prominent role in public and political debate. And parody, like all protected speech, need not be high-minded or respectful to find safe haven under the First Amendment. One of the prerogatives of American citizenship is the right to criticize public men and measures, and that means not only informed and responsible criticism, but the freedom to speak foolishly and without moderation. The art of the cartoonist is often not reasoned or even-handed, but slashing and one-sided. We uphold this right, even where parody shocks us, because our trust in the good sense of the people on deliberate reflection goes deep. Whether Novak's page was a protected parody is a question of fact that we cannot answer at this stage. The Court of Appeals interpreted the jury's findings in Hustler to be that the ad parody was not reasonably believable, and in accordance with our custom, we accept this finding. Instead, the jury will have to answer that question. At this stage, though, Novak has alleged enough facts that a reasonable jury could find that his page was a parody. Since we accept for now that the page was protected speech, we move to the second question: did the Parma police have probable cause to arrest Novak? Probable cause exists where there is a fair probability or substantial chance that officers will discover evidence of criminal activity. To answer this question, we need more facts. We need to know whether the citizen calls to the police station gave the officers probable cause to think there was a disruption or interruption of police operations under Ohio law. Thus, whether the police had probable cause to arrest Novak is an issue of fact which we do not have jurisdiction to decide. Of course, a retaliation claim is like a flowchart. Once you decide one issue, it leads to the next, so we move on. In the probable cause inquiry that follows, we assume Novak's page was protected speech. If the police did not have probable cause to arrest Novak, then he may bring a claim of retaliation. To prevail on his claim, Novak will need to show that the officers arrested him based on a forbidden retaliatory motive. But retaliatory motive is often difficult to prove. After all, protected speech is often a wholly legitimate consideration for officers when deciding whether to make an arrest. A plaintiff alleging retaliatory arrest must disentangle those legitimate considerations of speech from any wholly illegitimate retaliatory motives. To do so, the threshold question Novak must answer is whether retaliation was a substantial or motivating factor for his arrest. Novak bears the burden of making that showing. If he does, the next question is whether the officers would have arrested him absent that retaliatory motive. The burden to answer that lies on the officers. If they show that they would have arrested Novak even if he had not criticized the police department, his retaliatory arrest claim fails. So the questions will be, can Novak show that the officers were motivated by retaliatory animus, not legitimate motivations? Novak's burden. If yes, can the officers justify Novak's arrest based on something other than retaliation, a mistaken but honest belief that there was probable cause? That's the officer's burden. If the officers did have probable cause, on the other hand, they are entitled to qualified immunity. There we go. All done. Call it a day. Good night. If the officers did have probable cause, on the other hand, they are entitled to qualified immunity. The Supreme Court has said as much. This court has never recognized a First Amendment right to be free from a retaliatory arrest that is supported by probable cause. The Supreme Court said that in 2012, and it remains true today. So that's really important. You can be arrested in a retaliatory fashion if the police have a legitimate reason to arrest you. So in other words, if you're walking around the street, a free man or woman, and you have, say, an open arrest warrant, maybe even something active that allows them to come and pick you up at any time, because not all arrest warrants allow them to just come and pick you up at any time. Sometimes things are more like they can arrest you only if you come in contact with them through other means, like a broken taillight or something, or worse. So let's say that they have an active warrant where they can arrest you, but they just haven't gotten around to it yet. So you go on Facebook and say, F the police. And they say, okay, well, we were, kind of looking the other way. We can now, let's just go and get this guy who said this. Because we don't like him. That's perfectly fine. There is no violation of your rights if the police came and got you for a legitimate arrest, but they only came and got you because you ticked them off and it was in retaliation. That's what they're saying here. The Supreme Court decided 2 retaliation cases after Reichley, which was the one they were talking about above. Neither case clearly established Novak's right to be free from retaliatory arrest, etc. So Novak does not have a right to be free from retaliatory arrest unless it is unsupported by probable cause. And I think we're going to skip ahead here. To sum up, to resolve the retaliation claim, the fact finder will have to decide whether the page was a parody, protected speech, whether the officers had probable cause to arrest him under Ohio statute. If they did not have probable cause, they are not entitled to qualified immunity, and Novak can attempt to show the arrest was retaliatory. If the officers did have probable cause, then they are entitled to qualified immunity, even if the page is protected speech, because the law at the time did not clearly establish that charging Novak under the statute would violate his constitutional rights. So that's really interesting. We're gonna just skim through the next 10 pages and see if there's anything else interesting in here. So this is future issues, something about the Supreme Court holding recently in the Neves case, which I think we did read, and that was another one that was like the Reichley case before that said that a retaliatory arrest was okay as long as there was a proper basis for the arrest. The Neves case, First Amendment retaliatory arrest claim, plaintiff must generally show that there was no probable cause for the arrest. But the Neves case also recognized a narrow exception to this rule where officers have probable cause to make arrests, but typically exercise their discretion not to. So that might be like an equal protection kind of thing. This exception was not clearly established under Neves or before Neves, so it doesn't apply to Novak's case. Like I said, the Neves case was just decided this year. Issue 2. Even if Novak's case would not fall within the narrow exception, there is good reason to believe that in the future, probable cause alone may not protect the officers. First, this case may not be subject to the general rule of Neves because the sole basis for probable cause was speech. Besides posting to his Facebook page, Novak committed no other act that could have created probable cause. In other First Amendment retaliation cases on point, by contrast, the defendant's conduct was a mix of protected speech and unprotected conduct. That is, the defendants both said something and did something, like acted aggressively towards officers in an intoxicated state or something like that. They give various examples. Here we have nothing like the unprotected conduct. Novak did not create a Facebook page criticizing police and use his computer to hack into the police servers or something like that. This is important because in Neves and its predecessors, the court based its reasoning on the thorny causation issue that comes up in cases with both protected speech and unprotected conduct. Second, this case strikes at the heart of a problem the court has recognized in recent retaliation cases. There is a risk that some police officers may exploit the arrest power as a means of suppressing speech. The jaywalking exception acknowledges that officers can use probable cause as a pretext for retaliation. In such a case, probable cause does little to prove or disprove the causal connection between animus and injury. Novak's case is prime ground for the pretext that the Supreme Court was worried about. So this could go up to the Supreme Court if it's not resolved properly, is what the court's saying. For one, potential probable cause was based on protected speech alone. That is not dispositive because the officer's consideration of his protected speech may have been wholly legitimate. Remember, the court hasn't decided this yet. We're just in this early stage of the thing. The dog knocked a bottle over. But the fact that the arrest was made based only on protected speech at least raises a concern that probable cause does little to prove or disprove the causal connection between Novak's criticism of the police and his arrest. Issue 3, the vague language of the Ohio statute further heightens the concern in issue 2. The statute makes it a crime to use any computer or the internet so as to disrupt, interrupt, or impair the functions of any police operations. To see how broad this statute reaches, consider an example. An activist tweets the following message: "The police are violating our rights. Hashtag take action, hashtag make your voice heard." People in the community see that tweet and begin calling the police department to share their views. A small protest forms. Police station employees spend time fielding calls, and a couple of officers monitor the protest. Under the plain text of the Ohio statute, have these acts engaged in interruption of police operations? So there has to be evaluation of that, the court is saying. So then there's other claims like prior restraint that survives. We'll keep going. So prior restraint is making a rule or making a law or policy or taking action, in this case, to restrain someone's freedom of speech. And as you saw above, there are very few exceptions to the freedom of speech. The government cannot make any laws except against fraud and incitement, et cetera, et cetera, et cetera. Yes, only in North Korea does the government have a law against excitement. Maybe a little bit in China too, but that's only if you aren't straight. Novak also plausibly alleges that the officers created a prior restraint with their press release threatening to take legal action. So that's what that's based on. Another First Amendment claim, it fails because they are not based on clearly established law. Anonymity is not a clearly established law. Search and seizure and malicious prosecution. Let's see. These claims survive. So search and seizure violations and malicious prosecution survives at this stage. Privacy, that claim survives for now. Supervisory liability, or are we... I forget what the doctrine of respondeat superior, is that what this is? Novak seeks to hold their supervisor liable for their constitutional violations, and that is not something that, here we go, respondeat superior, that's not something that under 42 USC 1983, that does not work that way. Okay, so the claim survives. He can be held for his own actions, but so Novak must allege that the supervisor encouraged the unconstitutional conduct, which he has alleged, so that claim survives. Conspiracy, that looks like that survives. The municipal liability, the district court denies the claims because we don't have jurisdiction. The appeal is limited to qualified immunity. Okay, this is the appeal that we're in. So the appeal doesn't work with municipal liability because that's not the appeal. State claims we're going to skip. The court concludes, though Novak's Facebook page mocking the Parma Police Department has since left the cyber world, several of his legal claims will live on, others will end here. We reverse the district court's decision to deny the motion to dismiss on Novak's claims related to anonymous speech, censorship in a public forum, and right to receive speech. We affirm the district court's decision with respect to all other claims except municipal liability, over which we lack jurisdiction. So that's interesting. That's a very good explanation of parody, what it takes, the American values that we hold in parody, and we'll keep an eye on the Novak versus City of Parma case and see what happens there. Okay? Let us know what you think in the comments below.
I just had one question. So what exactly was the charge that he was arrested on? It was like interfering with police business?
Yeah, basically, causing an interruption or disruption of police affairs or business. Sort of, kind of like wasting police resources kind of thing.
Because I'm having a hard time trying to figure out how. So if something is a parody, it's protected speech. So I can't think of a real justification for being able to say, well, you're allowed to make a parody, except if it interferes with our day-to-day stuff for all of 12 minutes of a phone call?
Yeah, as much as phone calls? We have a history of parody in the United States, we also have a history of egregious police action that requires a court to respond like this and remind them what parody is. And then, it just, it's easy for people to get a big head, I guess. I often look up from down here and wonder, how are you people running the show when you're so incompetent, with regards to certain decisions, like the decision to arrest Mr. Novak? How is it that these people have been put in this position? Those police officers will get a pension for life, for retirement and everything. They're protected by qualified immunity otherwise. So why do we let the people like that run the show and not hold them to a higher standard where these things are shut down way earlier and we don't have to get to a court case like this? Yeah, it's a whole bunch of people with fragile egos. It's not just one or two or three or four. It's what we often refer to as the blue shield going too far. Should people band together? Should there be a police officers union? Yeah, heck, absolutely. Police officers should have rights and be protected, et cetera, et cetera, et cetera, et cetera, et cetera. I am not attacking police officers. They do a wonderful service and obviously put their lives on the line. However, if anyone ever tells you that they don't need any oversight or accountability, they need more oversight or accountability. So that's our show, everyone. Thank you for joining me. I am Leonard French, your favorite copyright attorney. In the studio with me here has been Kaylee, and in the virtual studio has been Tactical Bra. Thank you to our monthly supporters on patreon.com/ljfrench and sponsors.org/law. Your financial support is what makes our channel possible. Thank you to Joshua Davis from TandaPay for his support at the $500 level in the month of July, and I even hear he's going to support in August as well. So thank you very, very much to Joshua Davis. Thank you to our $50 plus supporters: John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, and Snorre Wisotzky. And thank you to the $5 plus supporters who are scrolling on the LED panel behind me. All of those people will be in the description of the videos below. However, it's only $1 to get access to some of the behind the scenes stuff and our special supporter channel and all that, and our half-hour live streams on Sunday mornings. And we are planning on adding more live streams for the patrons, probably a Friday live stream. We'll see, like a question and answer kind of thing, and then we'll produce that video into a YouTube video. But if you want to be on the question and answer live stream, you'll have to be at least $1 supporter. So I'll leave some room here for dog video. Thank you very much. Love you all. I'm Leonard French, your favorite copyright attorney. Have a great week. Bye.